Hello, I'm Christina Thomas, a partner in Mayer Brown's Capital Markets practice. Today I am going to talk about one of the SEC's recent rule proposals applicable to public companies. On March 9, 2022, the SEC proposed new rules that, if adopted, would require companies to report information relating to cybersecurity risk management, strategy, governance, and material cybersecurity incidents. The public comment period has now closed, and according to the SEC's most recently published rulemaking agenda, adoption of a final rule is slated for April 2023. Note, though, that there is no requirement for the SEC to stick to that date, so a rule could be adopted before or after. In this microtalk, I will cover the SEC's proposed reporting requirements for public companies with respect to cybersecurity disclosure. But first, I think it will be helpful to start with some background information. Under the existing regulatory framework, neither Regulation SK nor Regulation SX expressly requires that cybersecurity risk management procedures, cybersecurity risks, or incidents be disclosed. However, the SEC's Division of Corporation Finance published disclosure guidance in 2011, which was followed by commission-level interpretive guidance issued in 2018. This guidance explained when companies may be required to disclose information in SEC filings related to cybersecurity risks and incidents under the principles-based disclosure framework in response to current materiality-based disclosure requirements. The current SEC would like to replace the principles-based disclosure approach in favor of more prescriptive disclosure requirements that it believes will produce more timely and standardized information. I'll turn now to the specific proposed reporting requirements for current and periodic reports. The SEC's proposed new Item 105 of Form 8K would require an 8K filing within 4 business days after a company determines it has experienced a material cybersecurity incident. Specifically, the following disclosure would be required: when the incident was discovered and whether it is ongoing, a brief description of the nature and scope of the incident, whether any data was stolen, altered, accessed, or used for any unauthorized purpose, the effect of the incident on the registrant's operations, and whether the registrant has remediated or is currently remediating the incident. In addition to the proposed 8K requirement, the SEC proposed amendments to Regulation SK. New Item 106D1 of Regulation SK would require updates to previously filed Form 8K disclosure on cybersecurity incidents. Disclosure would be required in the subsequent quarterly or annual report for the period in which the incident occurred. The SEC provides a list of non-exclusive examples of disclosure in the release. Another big change that would be required would be disclosure in a 10Q or 10K when a series of individually immaterial cybersecurity incidents becomes material when considered in the aggregate. In other words, if a company has experienced several cybersecurity incidents, each of which on its own would not be material such that an 8K filing would be required, but when considered in the aggregate, the existence of the incidents becomes material, a company would have to provide disclosure about the incidents in a public report. In addition to the reporting of specific incidents, the proposed amendments to Regulation SK would also require disclosure about a company's policies and procedures, if any, for identifying and managing cybersecurity risks and the company's cybersecurity governance, the board of directors' role in oversight of cybersecurity risks, and management's role in managing cybersecurity-related risks and implementing the company's cybersecurity policies and procedures. Specific disclosure about the board of directors' cybersecurity expertise would also be required. Proposed Item 407J would require each company to disclose whether any board member has cybersecurity expertise, and if so, the nature of such expertise. It is important to note that for this rulemaking, corresponding changes were proposed to Forms 20F and 6K. So if adopted as proposed, foreign private issuers would have additional reporting requirements as well. As I mentioned at the outset, the public comment period for this rule proposal is now closed, and we are waiting for final rules to be adopted. If adopted as proposed, public companies can expect not only increased disclosure about cybersecurity oversight in their SEC filings, but may need to evaluate their disclosure controls and procedures to ensure timely reporting in the event that a cybersecurity incident becomes material. To learn more, visit our free writings and perspectives blog. Thank you.